Welcome to online class on Transfer of Property Act. On the other day, we had discussed the provisions of Transfer Property Act up to section 17. So on section 17, I think there should be a further repeat discussion. So what section 17 says? Direction for accumulation. Accumulation means gathering. Direction for accumulation, or keep or gather or keep accumulate somewhere. What it says? Where the terms of a transfer of property direct that the income arising from the property shall be accumulated. Accumulated means that will be kept, that will not be enjoyed or be accumulated. So when in a transfer of property there is a direction that the income arising out of that property shall accumulate either wholly, either entire the income is accumulated, or a part of the income is accumulated during a period longer than the life of the transferor, or a period of 18 years from the date of transfer. Either there is option, that is either a person can direct in the transfer that the income arising out of the property transfer, that shall accumulate, that immediately the transfer will not the income of the property. Income of the property will accumulate during his lifetime for the period after his death only that income will go. That longer period than a period longer than the life of the transferor, or a period of 18 years from the date of the transfer. Whichever earlier is not there, but either option is given to the transferor, either to direct that the income of the property may be accumulated for a period of 18 years or during his lifetime. Then such direction shall, save as hereinafter provided, subject to condition as provided, be void, to the extent to which period during which the accumulation is directed, except the longer of the aforesaid period. If a direction has been given that the income of the property will be accumulated for a period of 25 years, no, so at best the accumulation can be made for a period of 18 years. So after expiry of that period of 18 years, then the property income will go to the transferee. And at the end of such last mentioned period, that means either they suppose lifetime, the property and the income thereof shall be disposed of as if the period during which the accumulation has been directed to be made has elapsed. That means after the expiry of that period of 18 years, then the property and the income thereof shall be disposed of, shall immediately go to the transferee as if such a direction is not there. So this section 17 permits a transferor to give direction or to make a condition in the transfer that the income arising out of that property transfer may be accumulated. May be accumulated, that means may not be taken, may not be utilized. That means during the lifetime of the transferor or for 18 years. Or 18 years. If at the expiry of such period, as aforesaid, that means after expiry of the lifetime, if a condition is there, or 18 years after that condition is over, after that period is over, then the property and the income of that will go to the transferee as if such a direction is not there. This section shall not affect any direction for accumulation for the purpose of 3. Though there is a restriction that the income arising out of the property which has been transferred, that can be accumulated for a maximum period of 18 years or during the lifetime of the transfer, but this will not be applicable to certain kinds of transfer. That means certain type of direction regarding accumulation. When the direction has been given for the payment of the debts of the transferor or any other person taking an interest under the transferor. So, if a direction has been given that the income arising out of that property will be applied for payment of debt or of any other person taking an interest on the transferor, any other person who has taken any under the transferor. So here, in such case, this direction of accumulation may be made beyond the period of the lifetime of the transferor or beyond the 18 years. Second, the provision of portions for children or remote issue of the transferor. Portion means for the maintenance or for payment of education expense, etc. That is portion. Provision for portion for children. Suppose a accumulation has been made, direction has been given that the income of the property will be accumulated and that will be applied for the education expense of the children of the transferor, or a remote issue of the transferor, or any other person taking any interest under the transferor. Any other person getting any interest on the transfer is any issue is in your relative. Then such a accumulation may be made, direction may be given that the income of the property may be accumulated beyond the period of 18 years or beyond the lifetime of the transferor. The third is the preservation or maintenance of the property transferred, and such a direction will be made accordingly. Suppose X, a transferor, transferred a property or gifted a property to Y, and that property is a tank. Suppose there is a direction in the document, gift deed, that the income arising out of that tank, out of that, if 5,000 or 10,000 will be kept in bank account, and out of that amount, the embankment of that tank will be maintained. So in such case, such a direction may be given, though it exceeds the period of lifetime of the transferor or 18 years. So this is in nutshell this section 17. In a transfer, there may be direction for accumulation of the income of the property, and such a period may be, the period of accumulation may be either the lifetime of the transferor or 18 years from the date of transfer. And if a direction has been given for accumulation of the income of the property transferred beyond the aforesaid period, beyond the above period, that is beyond the lifetime of the transferor or beyond 18 years from the date of transfer, then such income will be utilized. That property and the income will be taken by the transferee as if such a direction for accumulation has expired, has elapsed. But this direction, this condition will not be applicable. There may be direction for accumulation, either whole or in part, for even exceeding the lifetime of the transferor or exceeding the period of 18 years, when such direction is given for payment of debt of the transferor or any other person in who is the transferor has any interest. Or second, when such direction has been given for the portion or for the maintenance expense or education expense, even marriage expense of any children of the transferor or any other person taking an interest under the transferor. Third is when such direction has been given for the maintenance or preservation of the property which has been transferred. This is section 17. Now let us come to section 18. What section 18 says? The restriction in section 14 and 16 and 17 shall not apply in the case of a transfer of property for the benefit of the public, then in the advancement of religion, knowledge, commerce, health, safety, or any other object beneficial to mankind. What is restriction? Section 14 is rule against perpetuity. What section 14 says? As you know, no transfer of property can operate to create an interest which is to take effect after the lifetime of one or more person living on the date of such transfer, that the intermediary during the lifetime of the intermediary, and the minor of the person who shall be in existence at the expiration of that period. So that is section 14, rule against perpetuity. Why rule against perpetuity? Because their property should not be tied up in the hand of a particular person or in perpetuity for an indefinite period. So a property can be tied, because if that will happen, that will hamper the financial condition or the commercial transaction, or that will hamper the progress of the country. Both industrial progress and the commercial progress of the country will be hampered if the property is tied up in the hand of a particular person for an indefinite period. Keeping this thing in mind, the legislature has made provision in section 14, that is rule against perpetuity. At best, the property, that means property can be tied up in the hand of an intermediary, and if it is for the benefit of the unborn person, then during the minority of that person. So that is section 14. Similarly, section 16, transfer to take back from failure of prior interest, whereby reason of any rules contained in section 13, 14, an interest created to the benefit of a person of the class of person fails in regard to such person, or the whole of such class, any interest creates in the same transaction and intended to effect after upon failure of such prior, it also fails. So that's why section 18 provides the restriction in section 14, 16 and 17. Suppose there is a direction that the property is tied up in the hand of a person beyond the period of the lifetime of the intermediary and minority, and the period of minority in case of unborn person. Or section 16, the prior interest fails because of it hits the provisions of section 13 and 14. Or there is a direction which is hit by the provisions of section 17, that is accumulation. These restrictions shall not apply in the case of a transfer of property for the benefit of the public. If a transfer has been made for the benefit of the public, what one? In the advancement of religion, advancement in the progress, in the improvement of the advancement of the religion, knowledge, commerce, health, safety, or any other object beneficial to mankind. This section provisions the restriction as laid down in the Transfer Property Act in section 13, 14 and 16 will not be applicable when such a transfer has been made in the advancement for the benefit of the public, in the advancement of religion, in the advancement of knowledge, for benefit or safety, health or commerce or any other object. Now we will discuss very important provision in the Transfer Property Act regarding vested interest and contingent interest. What do you mean by vested interest? Sometimes in a layman talks whether you have any vested interest in the property. So vested interest means what? Vested interest means that is an interest which has been already given to a person who has acquired a present right in the property. See, what is vested interest? That is a right which has been present right and present possession, present right and present possession, or present right of future possession. A right is given and thereby there may be future possession. So vested interest has been defined in section 19. What it says? Where on a transfer of property, what it says? In favor of a person created, where an interest is created. Always in a transfer of property, an interest is always created in favor of a transferee. Where on a transfer of property, an interest is created without specifying the time when the transferee will take interest in that property, when that will take effect, or with a condition that what? Or on the terms of the transfer specify that it is to take effect forthwith. The terms of the transfer provides that such interest is to take effect forthwith, or it will take effect, or it will take effect on the happening of an event which must happen, then such interest is vested. So what is a vested interest? When on a transfer of property, an interest then is created in favor of the transferee without specifying the time that when it will take effect. For an example, X transferred a property by way of gift and to Y without specifying the time when that gift will take effect. Then that will be treated as vested interest, transferee has a vested interest. Similarly, when on a transfer it has been provided that the interest in the property will forthwith pass to the transferee, that is a vested interest. Or when on a transfer an interest is created that which will take effect on the happening of an event which must happen, then that will be also treated as vested. So suppose a transfer property to be with condition that after the death of his wife, she will get the property. So the death of B is certain, that must happen. So here she has a vested interest. Similarly, A transfers a property to B with a condition that you will get that property after 1 year. So after 1 year, that is happening is certain, because in future there will be 1 year will pass. So here all are vested interest. Vested interest means present right possession, present right, immediate right is given. So here present or even a future possession, that will also be a present right, and even future possession is there, then that interest will be treated as vested interest. But it has been provided a vested interest is not defeated. When a vested interest is created, that will not be merely on the ground by the death of the transferee before he obtains possession. The section provides that when a vested interest has been created in favor of the transferee, if the transferee dies prior to getting possession of the property, that interest will not be defeated. When immediate transfer, present right, present possession, that vested interest. But present right is given, but future possession, that is also vested interest. Or on the happening of an event which must happen, the transferee will get the property, will get the interest property. So if the transferee dies before obtaining possession of the property, the vested interest will not be defeated. The explanation provided to this section says, an intention that the interest shall not be vested is not to be inferred merely from a provision where the enjoyment thereof is postponed. As I told you, that when the property is given, transferred with a condition that you will enjoy that property after 2 months or after 1 year. So from that condition, there should not be an inference that it is not a vested interest. An intention that an interest shall not be vested, that intention shall not be vested, not to be inferred merely because the enjoyment of the property has been postponed, or where a prior interest in the same property is given or reserved to some other person, like transfer for the benefit of one person. When a prior interest is given or is to be given or reserved for some other person. So here, when a transfer is made in favor of an unborn person for the benefit of a person, giving that property in the hands of an intermediary, from that there should not be an inference that there was no intention of creating vested interest in favor of that unborn person, or or in the direction arising, or that the income arising from the property is directed to be accumulated until the time your enjoyment arrives, or when there is a direction that the income arising of that property will be accumulated till the enjoyment arrives. From, if such a direction is given, from that direction it should not be inferred that there was no intention of the transferor to create any vested interest of the transferee in respect of that property, or from a provision that a particular event shall happen, the interest shall pass to another person. Or even if there is a provision in the transfer that if a particular event shall happen, then the property will go to another person. For an example, X transferred a property to B with a condition that if B will die during the lifetime of A, then the property will go to C. Because there is a direction that the property will go to C if B dies during the lifetime of A. So from that direction and intention, it should not be inferred that the transferor had no intention to create any vested interest of the transferee in respect of that, over that property. So now, what is vested interest? You should always keep in your mind. What is vested interest? Vested interest, it has been defined in section 19 of the Transfer Property Act. What it says? When on a transfer, an interest is created without specifying the time when it will take effect. Second, or that such interest will take effect forthwith. Or third, that it will take effect on the happening of an event which must happen. Then such interest is to be treated as vested interest. So vested interest will not be defeated merely because there is direction in the transfer that the enjoyment there is a condition that the enjoyment in the property is postponed for certain period. Again, explanation says, as because there should not be inference that there is no intention of the transferor to create a vested interest whereby the enjoyment of the property has been postponed, or there is a prior interest has been created in or reserved in favor of some other person, or whereby income arising out of the property has been directed to be accumulated until the time of enjoyment of the transferee, or a provision that if a particular event shall happen, then that property will go to another person. Now, coming to section 20 of the TP Act. What section 20 says? When an unborn person gets vested interest in the property. What it says? When unborn person acquires vested interest on transfer for his benefit. When a transfer has been made for the benefit of an unborn person, when that unborn person acquires vested interest in that property. As you know, there may be transfer for the benefit of unborn person, creating a prior interest in respect of that property in favor of an intermediary, and the whole of the remaining interest, that means all the entire interest of the transferor will absolutely go to the transferee. That means unborn person. This is conditioned in section 13. There may be a transfer in favor of for the benefit of a person by creating prior interest in favor of an intermediary and by giving the absolute interest of the property in the transferor in favor of that unborn person. So, when such a transfer has been made, when the unborn person will acquire vested interest in that property. This section 20 makes it clear. What it says, where on a transfer of property, an interest therein is created for the benefit of person not then living. That means he is not born. He acquires upon his birth. So very moment that unborn person is born, that if child is born, then he acquires vested interest in the property unless a contrary intention appears from the terms of the transfer. If it has been specifically contrary intention has been mentioned there, then you will not get a vested interest or vested interest. Although he may be entitled to the enjoyment of thereof, he may not be entitled to enjoyment of thereof immediately on his birth. For an example, X transferred a property in favor of B who is living with condition that after his death, the entire property will go to his child who is not born. Or suppose he puts a condition that A transfer property B for life and then to such of the eldest son of B if he is born. Suppose the child is born, and also there is a direction that the eldest son will get the property after 10 years. Because at best the property may be, interest may be postponed during the minority of the unborn person. So 10 years. So here, though there is postponement of giving the property to the unborn person for 10 years in this transfer, very moment the eldest son is born to B, he acquires a vested interest in the property. What it says? Where on a transfer property an interest therein is created for the benefit of unborn person, then he acquires upon his birth, unless acquires vested interest upon his birth, unless a contrary intention appears from the term of the transferor. So here he acquires a vested interest, although he may not be entitled to enjoyment thereof immediately on his birth. So section 20 makes it clear that when a transfer has been made in favor of an unborn person, then when that unborn person is born, he acquires a vested interest in the property, though the enjoyment of that property is delayed, or there is delay that he cannot enjoy the property during his minority. So this is section 20. Now let us see what is, probably you understood what is contingent interest. Now you do not know what is contingent interest. Till now we discussed the vested interest. Then what is contingent interest? Contingent interest means when on a transfer of property, an interest is created in favor of a transferee, which will take effect on the happening or non-happening of an uncertain event, then such interest is called contingent interest. Suppose A transfers a property to B, mentioning that after the death of his wife, B will get the property. This is not a contingent interest, because it is to be treated as a vested interest, because death of his wife is certain. But suppose A transfer to B, to his daughter B, that she will get the property if she will marry a person of his caste. If B marries a person of his caste, then he will get vested interest. Then he will get the property. So here, on the happening of an event, an interest is created in favor of a person, in favor of the transferee, which will take effect on the happening of an event or non-happening of an event. Non-happening of an event means, suppose X transfers a property to B with a condition that he will get the property if his son who is in America will not return within a period of 5 years. Suppose his son did not return to India within a period of 5 years, then the transferee will get the property. So here in that case, this is called contingent interest. What he says, where on a transfer of property, an interest therein is created. Interest is created in favor of the transferee, which will take effect only on the happening. Only is very important. The word only on the happening of a specified uncertain event. The event is uncertain. Only on the happening of an uncertain event. The previous example is there whether if his daughter will marry a boy of his caste, that is uncertain. So here, or if a specified uncertain event shall not happen, happening or non-happening. As I have in the previous example, that A transfers certain property to B with a condition that he will get the property if A's son will not return to India within a period of 5 years. So there is uncertain event. His son may return to India or may not return, or happening or non-happening. Here non-happening, only non-happening, non-return, that B will get the property. If this happens, if he will marry, the daughter will marry, she will get the property. This is happening. When on a transfer property interest is created in favor of the transferee, which will take effect on the happening or non-happening of an uncertain event. Only and uncertain. You should understand this, give important emphasis on these two words. Only on happening or non-happening of an uncertain event. In vested interest, that the transferee gets this vested interest as the happening is certain, that on the happening of an event which must happen. But here contingent on the happening of only on the happening or non-happening of an uncertain event, then such interest is called contingent interest. Such person thereby acquires a contingent interest in the property. Then such interest becomes vested interest. That contingent interest becomes vested interest in the former case. That means on the happening of an event, then if that event happens, so he acquires vested interest. For an example, X has transferred a piece of land or a house in favor of his daughter Y, that with a condition that you will get the property if she will marry a boy of his caste. So when his daughter B married a boy of his caste, so the event happened. That uncertain event happened. So that's why this daughter B immediately, on the very day she marries, she acquires a vested interest in that property. So in the former case, when it happens, or in the latter case means that when the transferee will get the property on non-happening of an event, in the latter case, non-happening of an event, when that doesn't happen, or happening of that event becomes impossible. For an example, if that X has transferred property to B with a condition that he will get that property if his son, who is in America, will not return within a period of 5 years. After 1 month of the transfer, suppose his son, who was in America, he died. So now the non-happening, it becomes impossible. Because here, only not return from, if your son will not return to America within a period of 5 years, this transfer will get the property. But here the non-happening becomes impossible. So in the former case, when an interest, contingent interest has been created in favor of a person which will take effect on the happening of an event, then if that event happens, the transferee acquires a vested interest. Or when a contingent interest has been created which will take effect on the non-happening of an event, then that interest becomes vested. When that event does not happen, or happening of that event becomes impossible. So you should know. Except where under a transfer property, a person becomes entitled to interest therein upon attaining a particular age, and the transferor also gives to him what one exception is there. Though contingent interest, when contingent interest, though it appears to be a contingent interest, that will be treated as vested interest. That means when a transfer has been made, that a person will get the property only after attaining a particular age. Suppose a property has been transferred. A transfers a property to B, that he will get the property after attaining 30 years. What type of interest it is? It is a contingent interest. Because B may survive for 30 years or not. If B survives for 30 years, B attains 30 years, then you will get the vested interest in that property. But it is a contingent interest. So here, where there is a transfer, under a transfer property, a person becomes entitled to an interest therein upon attaining a particular age. If there is a contingent interest, that only that a person will acquire interest in the property after attaining a particular age, and the transfer also gives him to absolutely income to arise from such interest before he reaches that age. If the transferor, before the attainment of 30 years by the transferee, he has given the absolute income of that property to that transferee, or directs the income of so much thereof as may be necessary to be applied for his benefit, such interest is not contingent. So, only one type of contingent interest will not be treated as contingent, but that will be treated as vested interest. When a contingent interest is created in favor of a person, that he will get that property on attaining a particular age, that interest will not be treated as contingent interest, but it will be treated as vested interest when, prior to attaining of that age, the transferor has given the income of that property absolutely to the transferee, or so much interest as may be necessary to be applied for his benefit, or some interest or some income has been given for the benefit of that transferee, then such interest is not contingent. Now you try to understand the provisions in section 21. What it says, contingent interest, when on a transfer of property. On a transfer of property means what? Again, at the cost of repetition, I must say, remind you, make you remember that transfer of property means as defined in the Transfer of Property Act. What is that section? Section is probably this 5. That is 5. Transfer of property is defined. What it says? In the following section, transfer of property means an act by which a living person conveys properties in present or in future to one or more living person, or to himself and one or more living person. So that's why 21, on a transfer of property, where these words comes, you should understand the meaning transfer of property as defined in the Act. When on a transfer of property, an interest therein is created in favor of a person, which will take effect only on the happening of an uncertain event, or if a specified uncertain event does not happen, then such person thereby acquires a contingent interest in the property. Then such interest becomes vested interest in the former case. That means in the happening, if that event happens, non-happening, if that event doesn't happen, or the happening doesn't becomes impossible. But one exception is there. When a contingent interest is created, that the transfer will get the property only on attaining a particular age. If prior to attainment of that age, the income of the property is given absolutely to transferee or for his benefit, then such interest will not be treated as contingent interest, then it will be treated as vested interest. Now let us discuss the provisions in section 22. What section 22? Transfer to members of class who attain a particular age. Where in a transfer property, an interest therein is created in favor of such members only of a class. Class means what? In a group. Class means of a group. When on a transfer of property, an interest therein is created in favor of such member only of a class as shall attain a particular age, such interest does not vest in any member of the class who has not attained that age. Previous, you should read this section along with this section 20. What is section 20 says? When a property is transferred in favor, for the benefit of an unborn person, then that unborn person acquires vested interest in the property by his birth, though the enjoyment of his property is delayed as per the provisions of section 14. But section 22 says, when there is a transfer for the an interest therein created in favor of some members only of a class, members of a class, as shall attain a particular age, such interest does not vest in any member of the class who has not attained that age. Suppose X transfers that property to B for life, and then to such of the children of B who must have attained the age of 10 years by the time of his death. So all sons of B, unborn sons of B, if some of the son has not attained the age of 10 years, by the date of death of A, that means B, then he will not get any interest. So what it says? Where on a transfer property, an interest therein is created in favor of such members only of a class as shall attain a particular age. On attaining a particular age, he will get interest in that property. Such interest does not vest. Then such, though provision is there by birth, the unborn person gets vested interest, but such person will not get any vested interest in the property in any member of the class who has not attained the age, because this is an exception to provision section 20. Now we have come out, then these are the sections regarding contingent interest. Transfer contingent on happening of a specified uncertain event. Section 23. Where on a transfer of property, an interest therein is to accrue to a specified person if a specified uncertain event shall happen, and no time is mentioned for the occurrence of the event, the interest fails unless such event happens before or at the same time as the intermediary or precedent interest ceases to exist. What is? No time is specified. What? A transfers a property to B for life, and then to C if he will marry during the lifetime of, if she will marry a boy of his choice. So here, where on a transfer of property an interest therein is to accrue to a specified person, if a specified uncertain event shall happen, on the happening of specified uncertain event it shall happen, life interest, and no time is mentioned, that is no time within 5 years or 10 years that will happen, then the interest fails unless such event happens before or at the same time as the intermediary of the precedent ceases to exist. Though prior to her marriage, the intermediary dies. So thereby the interest of the intermediary ceases. If suppose A has transferred a property to B, and with a condition that if during the lifetime of B, his daughter will marry, that she will get the property. Suppose the daughter doesn't marry during the lifetime of B. So prior to cessation of interest of B, the event does not happen. So that's why you will note that interest also ceases to exist. What it says? Where on transfer property, an interest therein is to accrue to a specified person if a specified uncertain event shall happen. Uncertain event shall happen, you will get the property, and no time is mentioned. No time is mentioned within which that specified uncertain event shall occur. The interest fails unless such event happens before or at the same time as the intermediary or precedent interest ceases to exist. Let us conclude our session. In the next session, we'll discuss the other provisions regarding contingent interest, then I will you will make a differentiate. What is you will distinguish what are the contingent interest